huge setback for the LGBTQI community in India. Well, as the top court today in its landmark verdict unanimously refused to recognize same-sex marriage in India. The court, however, has recognized the right to live together and right to union for the LGBTQI community. The court also in its verdict rejected the plea of the queer couples to adopt children. The court has put the onus on the parliament to frame a law over same-sex marriage. The court agreed with the government's proposal to set up a committee to look into this issue. The Chief Justice also directed the centre a slew of measures to be implemented that included forming an anti-discrimination panel, equal rights and ration card, prevention of harassment, pension and gratuity rights, among others.
Queerness is not urban or elite. The discussion in this segment has not scratched the surface of the rich history of the lives of LGBTQ persons in India, which continue into the present. Yet even the limited exploration of the literature and reportage on the subject makes it abundantly clear that homosexuality or queerness is not solely an urban concept, nor is it restricted to the upper classes of privileged communities. The discussion in the preceding paragraphs reveals the diversity of the queer population. People may be queer regardless of whether they are from villages, small towns, or semi-urban and urban spaces. Similarly, they may be queer regardless of their caste and economic location. It is not just the English-speaking man with a white-collar job who lives in a metropolitan city and is otherwise affluent who can lay claim to being queer, but also and equally the woman who works in a farm in an agricultural community. Persons may or may not identify with the labels queer, gay, lesbian, trans, etc., either because they speak languages which are not English or for other reasons. But the fact remains that many Indians are gender queer or enter into relationships with others of the same sex. In the words of a person assigned female at birth who worked at a factory in Ajmer, and I've quoted to imagine queer persons as existing only in urban and affluent spaces is to erase them, even as they exist in other parts of the country. It would also be a mistake to conflate the urban with the elite. This renders invisible large segments of the population who live in urban spaces but are poor or otherwise marginalized. Urban centers are themselves geographically and socially divided along the lines of class, religion, and caste, and not all those who live in cities can be termed elite merely by virtue of their residence in cities.
All decisions relied upon Puttaswamy, Navtej, Shakti Vahini, and Deepika contain broad observations with respect to individuals' choice of their partners, and also a reference to non-conventional relationships. Some observations are undoubtedly to be found in these judgments that cannot be referenced to hold that a right to marry automatically flows from the manner of the provisions of Part 3 which the petitioners assert. There cannot, for the above reasons, be a per se assertion that there exists an unqualified right to marry, which requires treatment as a fundamental freedom. We agree on this conclusion arrived at by the learned Chief Justice and his analysis of all these cases, that the Constitution does not expressly recognize a right to marry. While we agree that there is a right which we characterize as a right to a relationship, which is recognized in Navtej, that the queer couples and other relationships of that kind can have a union. We characterize it as a right to relationship to avoid confusion. We squarely recognize that it falls within Article 21, as already recognized in these cases. The right to relationship here includes the right to choose a partner, to cohabit and enjoy physical intimacy with them, to live the way they wish to, and the other rights that flow from the right to privacy, autonomy, and dignity. They are, like all citizens, entitled to live freely and express this choice undisturbed in society. Whenever the right to enjoyment of such relationship is under threat of violence or coercion, the state is bound to extend necessary protection. That is the natural consequence of this court's judgments in Navtej, Puttaswamy, etc.
Listening to a series of reactions that came in after the unanimous verdict by the Apex Court.
I see queer persons, lesbian, gay, queer people, transgender people, intersex people, asexual people as citizens of this country. As citizens of this country, as human beings on this planet, we all come with certain rights. we shall see whether the court recognizes the right to marry, the right to choose the person that we love or not. Let us see what happens. We have worked very hard. The struggle has been there for a long time.
अभी किसी को इस कगार पे नहीं आना चाहिए कि हमारी सारी जिंदगी उम्मीदों पे कायम रहे। तो अभी हमारी उम्मीद ये है कि हम इक्वल राइट्स जीतेंगे। हम जिससे प्यार करते हैं उसके साथ शादी कर सकें। हम ये चाहते हैं ताकि हमें संवैधानिक हक मिले।
We look at it with disappointment. I was following it mostly. Some of the judges had said some really pertinent points, which really made me very happy, because they've looked into all the aspects, the social, the legal, the spiritual, the religious, all kinds of aspects. And so I thought, listening to one of the judges and the conclusions that he said, I already was exhilarated. I thought, oh my God, today is going to be the judgment day where gay marriage is going to be legalized. So I thought positively, and so I came running to this place where we all meet up. Oh, it's a drop-in center. But then the other judges, one by one, were delivering, and then finally the judgment is to say that, we cannot change the law or make new law. It has to be the parliament that has to do it, which really disappointed all of us.